Okay, good morning to the latest in our 10-minute takeaway slots. And this morning I am joined again by Mr. Jon Sharp, who's the insurance specialist at Ash. And John's going to be giving us the latest in the ongoing saga of COVID-19 and the insurers' response. So good morning, John.
Good morning, Julie. How are you?
I'm good. How's life in sunny Scotland?
It's very sunny at the moment, very good. And I put another tie on, Julie, because I look back at our vlogs and realised I've been wearing the same tie. So people might think that poor man, he's only got one.
What a fashion faux pas.
I put a new one on today.
We are deeply honoured, believe me.
There we go.
Okay, so there's been some further developments in the FCA versus the insurers case. Can you just remind everyone of the background to the case?
Yes, certainly. The FCA, a regulator with teeth, as I've described before, has jurisdiction over basically all financial companies in the UK. That's insurance and banking as well. And it has three main, I suppose, mantras at its core. The first is it deplores uncertainty in any of the market that it regulates. Secondly, it wants to make sure that all customers are treated fairly. And thirdly, that those that it regulates are seen to be doing the right thing in accordance with the FCA rules. Now, it became concerned in March about insurers' response to business interruption claims as a result of COVID-19 and the action of the government in terms of ordering businesses to close, etc. Now, it soon realised that if it didn't take some action, there would be thousands of pieces of litigation against insurers, all claiming effectively the same. You should be paying us under its business interruption as a result of the action of the government caused by a notifiable disease, namely COVID-19. So there would have been thousands of cases. It also realised the hardship that was being caused to businesses and that many businesses hadn't simply got the resources, especially at the moment, to take on insurers. In addition, it was very, very surprised by the amount of public anger directed against insurers and decided that it better do something about it. Its problem is that there were some 78 different types of wording which dealt with actions of government, etc., and business interruption clause and business interruption generally. Now, just let me give you a classic example of a business and of what would be a normal, everyday business interruption case. Okay, so you own a fish and chip shop. You've opened it in a nice new area which hasn't got a fish and chip shop, and you kit it out with all the latest gear, your new fryers, etc., and you do nice crisp chips, and you've got a nice batter recipe, and you do very well. And then suddenly, through no fault of yours, one of the fryers develops a fault and causes a fire in the premises. Yeah? Now, even the basic insurance policies will pay for the damage to the premises caused by the fire, but will also pay you business interruption, normally based on turnover for the period that you're closed during the refurbishment. Right. So you're put back into the position that you were immediately before the fire. Yeah? I think we all get that. That's classic stuff. The problem that there was here was that in the more expensive business insurance policies for which people had paid additional premium, there was also coverage for closure by local authorities and governments, and also closure as a result of a notifiable disease. So if you like, they are non-damage covers, and these were squarely in focus. So what the FCA did is it entered into a framework agreement with some 8 insurers who between them had 21 policy wordings. On the basis that these 21 policy wordings covered all the major issues and all the other 78. The framework agreement itself really just meant that the case could be brought to court very quickly. There was cooperation between everyone, exchange of pleadings, etc. And that was all mutually agreed. However, that was the last thing that was mutually agreed. The FCA argued against insurers on every last single point.
Wow.
And we know now that the judgment was actually handed down on Tuesday of this week.
So what does the judgment say?
Well, the judgment, and not surprisingly, considering there was some 21 barristers before the court, all done by video link, was 165 pages long.
Ouch.
Now, I've read it. I've been reading judgments for 32 years, and I have to say that this is one of the more complex judgments that I've read. That's not the fault of the judges, Lord Justice Flo and Lord Justice Butcher. They have a great deal of ground to cover, and when they make decisions, they have to justify their decisions. However, if you want to look at the best summary of the case, then please go to Herbert Smith Freehill's website. Don't normally, obviously, try to promote with the lawyers, but it's a very good summary, and it will be because they represented the FCA in the dispute.
Right.
However, shortly, the FCA won. The court found that in a good majority of the policies before it, there was cover and the policies should respond. Now, there is cover, therefore, for business insurance caused by either government action and notifiable disease and or both.
Right.
Now, there we go. So it's good news for everyone because they have found that despite insurers saying COVID-19's got nothing to do with us, they'll say, oh yes, it has. So if you have a more expensive policy, you should have in it a clause which says you're covered if your premises are closed by government action, etc., or action of a local authority, and you should have some cover if you have got a notifiable disease extension. Okay? I say should,
Right.
because the FCA weren't wholly successful. Let me give you two examples. There's an insurance company called Ecclesiastical, and the courts looked at, I think, 3 of its policy wordings. And because those policy wordings were quite narrow, it said in those cases that no, ecclesiastical policies did not respond. Contrast that with the Hiscox policies. Now, Hiscox, I think as everyone knows, advertise themselves as paying all claims, and in addition, they provide very wide coverage. It's more expensive, don't get me wrong. You go to Hiscox for your household contents insurance, you'll be paying a lot of money, but you get very wide coverage. So not surprisingly, the courts found that in relation to the Hiscox cases, there was cover for business interruption. Hiscox, within 2 hours of the judgment being released, said they would be appealing. So there we are. However, it has made it slightly more complicated for everyone because although those 21 wordings looked at cover just about all clauses, they won't cover every one, and there will be slight differences between the 21 and the other 78, if you see what I mean.
Yep.
Clearly, if you had got a Hiscox policy and the judges have now said there is cover for business interruption, it's very good news. The other matter I should mention is that insurers relied heavily on a case called Orient Express Hotels, and forgive my pronunciation here, it's going to go horribly wrong, Aziguzora General Spa, which was a 2010 case. This was all to do with a hotel in New Orleans, which was physically damaged by Hurricane Katrina. Now, normally, going back to my fish and chip example, you'd expect there to be business interruption cover following that. Now, what's the courts decided in that case? That no, there wasn't, because of course the whole of New Orleans was devastated by Hurricane Katrina.
Yeah.
Everything was shut. So what business interruption could there possibly need? No one could have got there anyway.
Right.
However, the courts in this case distinguished that case, saying it's not the same facts, not the same circumstances, and ultimately actually decided, excuse me, Jake, actually decided that if the case had come before the courts now, they would find that it was wrongfully decided. So it was wrong.
Interesting. So what should people and companies now be doing in light of this decision?
Well, the first thing to do is to get your policy wording out. as I said, there is a very good summary of the position on Herbert Smith's website, and also all of the documentation, including the full judgment, is on the FCA's website. The best thing about this case is it's been entirely transparent. All the pleadings are there for everyone to read, and the judgment's there for everyone to read. So you need to get out your policy wording, and if in your policy wording you have got cover for closure of your premises by government action, etc., and you've got notifiable diseases in there, then you may well now be able to start recovering from your insurer. Now, clearly, if you've got one of the policies that was actually considered by the court, and they've actually found that there is, well, now's the time to start putting some figures onto your claim and submitting it and saying, right, well, the courts have now decided, so, you know, despite you all saying it's got nothing to do with us, it clearly has, and here's our business interruption loss claim, okay? Now, however, as said, there will be a grey area where your policy wording might not quite match the policy wording that's been decided upon. However, the advantage of this case now is, whereas before the case I mentioned earlier was really the only case of this type, now we have a full lengthy judgment which lawyers and brokers as well can compare your policy wording against, and it should make life now a lot easier for solicitors and brokers to decide whether or not you have got cover. And also considerably cheaper now for you to get an opinion from a solicitor, from your broker, about whether or not you have got the cover, because they've got something to measure it against now.
Yeah.
Yeah. Whereas before, it was all, well, I can see those. Now, there you go.
Yeah.
Have you got cover? Yes, you have.
Yeah.
So it will make life, certainly in terms of getting the opinion, a lot cheaper, because there is something to compare against. Okay. It still won't be very easy for your professional advisors, I have to say, because it's not still, as I said, a complex judgment, but it will be a lot easier for them to give you a definitive opinion now. Okay?
Excellent.
Now, secondly, if you have not claimed yet, and I know, Julie, I banged on about this for ages.
Once or twice.
Once or twice. If you have not claimed yet, do it now. Don't wait. Do it now. I still think you're going to bump into what's called late notification arguments, because many policies in the policy wording say you must tell us within 30 days that you are making a claim. And insurers may well turn around, and, you know, to be fair, with some justification, and say, where have you been for the last 6 months? So you may well run into a late notification argument, but it's worth a go still. So make a claim. Even if you can't quantify it yet, make the claim. There may be some scope to get round late notification arguments, because some insurers have been, what's the best word? Trying to deter claims, I think is the best way to put it. I had a client in the north who, when first rang their insurer said, well, we're not paying you, because if we pay you, we have to pay everyone. So not the best encouragement there. Some insurers have been writing to people saying, well, I know there's this FCA test case, but our wording is not included, so still no cover. Well, no, that wasn't right either. You know, we had a similar letter, and I responded robustly to our particular insurer.
Robustly. Interesting words, John.
But the main thing is to start speaking to lawyers and brokers now, because you may well find you do have some cover. It may not be the full amount, you may only have cover for one aspect of it, but if you've got notifiable disease, or you've got something that says closure by government action or local authority, get an opinion on it. It will be a lot cheaper now for you to get that opinion. That opinion may still not be favourable to you, but it'll be a lot cheaper to get it now than it was before. Okay? It will also mean that if insurers still refuse to pay claims brought under these two heads, that you may be able to use something called Part 8, which is a part of the CPR, basically the rules of the court. And that allows you to take straightforward cases to court relatively quickly and cheaply. So let me give you an example. You've got two companies that have been at loggerheads over a contract that they both entered into. Let's say they managed to resolve the vast majority of their differences. They, have some way of compromise, but there is just one part of it they just cannot agree on. They can't agree who's responsible for paying the losses. So what they will do is go to the court and say, right, this is the contract we entered into. No one disputes that we entered into it. There's no argument there. These are the facts. The bit we can't agree on is that clause there. Normally, you're not allowed to have witness evidence or any other expert evidence. Normally, it's just legal argument. Now, this case is going to turn primarily on legal argument.
Yeah.
So it may well be that you can, if insurers are still not paying your particular claim, go down this Part 8 route, which is a lot cheaper than a full-blown, you've got to disclose all your documents, exchange witness statements, etc. It's done on limited amounts of paper, and it's mainly legal argument. So bear that in mind as well. There will still be enormous arguments about quantum. Don't let anyone think that this is going to be, oh right, I've got cover now, they're going to pay. There will be lots of arguments about quantum. There was some guidance in the judgment about what could be recovered and what couldn't be recovered, but there is going to be an almighty fight about quantum. It will be easier actually for those that were ordered to shut.
Yeah.
Now, there were various categories in the judgment, category 1 to I think 9. Category 1 were those that were told to shut by the government, like restaurants, bars, etc. You must close. There was no argument about it, and if you didn't close, the police came around and shut you down.
Yeah.
So there can't be any argument that that was an act of a government and local authority, etc. Yeah. However, category 6, where you get offices, etc., well, they looked at all the statements, and actually, you look at them, the government didn't say close your office. I think it did in Scotland. I don't think it did in England. It said offices, you should go to your office only if you cannot work from home. That's not the same as saying you must shut. So there's various categories in there as well. And as I said, there will be quantum arguments. Well, what have you lost? Did you but lose that because of the downturn in the economy, or did you lose it because genuinely, when you were shut down, you couldn't trade? Again, it's going to be easier for restaurants and bars. They couldn't sell anything.
Yeah.
So, but for offices, again, I'm struggling slightly with that one. But anyway, you must read the judgment, you must get out your policy wording, and you must, if you're not sure, get some advice, either from your broker or from lawyers. Lastly, we haven't quite got certainty yet. There will be appeals. As I've said, Hiscox announced they're appealing within 2 hours of the judgment, and I'm sure others will. But equally, the FCA may well appeal, because I'm still not sure about this argument that the government didn't order you to close. What are you supposed to do when the government says, you really shouldn't be going to work at all? What alternative do businesses have? So they may appeal that aspect of it. But there will be appeals, of that there is no doubt. They'll probably be expedited to the Supreme Court to review the judgment. So I wouldn't say we're likely to get absolute certainty until the end of October. But now is the time to, if you are actually one of the lucky ones who's got one of those policies that's already been analysed by the court, you can submit your claim. Get your figures onto your claim, submit it. I'm not sure how long you should be able to claim for. I would have thought you'll probably only be able to claim for 3 to 4 months until things opened up again, which effectively was the start of July. When did I go back to work? August. So between July and August.
Yeah.
I think that will be the maximum limit. But it's still something, especially for restaurants and bars. Those that were ordered to close, they will have decent claims. I can't see any way around it. We couldn't do anything. We were shut. So there we go. The downside for everyone, though, absolutely everyone, is that it was already a hard insurance market before COVID-19.
Yeah.
So premiums were going up. Now that they are clearly going to have to pay money out in relation to COVID-19, everyone's premium, because it will be a market-wide hit, will go up.
Yeah.
By, I don't know, anything up to 50 to 60%. Because
Ouch.
insurers will pay, but they will claw it back through an increase in everyone's premium. So that's the downside to it. But on the positive side, lots of businesses that have been struggling, this is good news. And I have to commend the FCA for bringing this action. It's given everyone a template to work from, if nothing else now, whereas there was nothing before. Those that, unfortunately, only bought the basic cover, at least they've had, if you like, their day in court and they haven't had to pay for it.
Yeah.
Because you only need to look at the pleadings on the FCA's website to see that this was not a cosy little sort of agreed thing between regulator and regulated. This was a hard-fought battle between regulator and regulated. And the FCA left no stone unturned in challenging what insurers said. So, you know, it's the first time I've seen something as transparent as this. The Hiscox Action Group, who are also taking their own set of proceedings against Hiscox, and another group as well from the hospitality sector, were also allowed to make submissions to the court. So this was a comprehensive review of the whole situation. As I said, there will be appeals, but generally it's good news for those that have got the more sophisticated type of business insurance policies.
Right.
That's really it, Jules. That's just a little summary. Like I said, I cannot recommend enough that people go to Herbert Smith's website where there's a good summary of it, and also look at the judgment yourselves on the FCA website and compare the findings to your own policy work.
Okay. Well, thank you to you and your new tie for the update. And
I know, it's a nice. I like this tie. It's very good.
Lovely. Very nice. So as always, the advice is whilst the arguing is going to be continuing for some time, get the facts and figures on your claim and get that sorted now. And if you haven't yet made a claim, give it a try. Yeah,
I think that's got to be the answer.
Okay, so we will see you again on this topic next Thursday, 6 o'clock.
Yes, I will. Yes, I will slightly change the format. I will concentrate more on what the case has decided now, rather. But I'll have to still deal with a little bit of its run-up. But yeah, I'll make sure I concentrate on what the results.
Okay, well, thank you very much for your time, John. As always, it's a fascinating.
Thank you, Julie, for yours.
And we will speak to you soon.
Talk to you later.
Take care. Bye.